I'm excited now to introduce the highlight of our conference, the keynote from Vince Warren, the Executive Director for the Center for Constitutional Rights, who has already apparently met half the people in this room already. So thank you, Vince, for coming. I will say that in researching Vince for this introduction, I was surprised to find that there are actually a couple of other notable Vince Warrens on the internet. There is Vince Warren, the baseball player, who played a single season with the Giants. I'm sure there's some sort of story there. And there's also a Vince Warren, a famous ballet dancer and teacher from Canada. But I can assure you, though, that our Vince Warren is probably the most notable of this crew. So there are many things I could obviously highlight about Vince's career, which you can read about more extensively in our program. His work has taken him everywhere, from South Africa's Truth and Reconciliation Commission to Guantanamo Bay to the streets of New York City. But I want to focus on one aspect of his work today that I find fascinating. Vince's career and the organization that he leads, the Center for Constitutional Rights, or CCR, truly model what it means to be an organization, to be an institution that conceives of human rights as civil rights, and of civil rights as human rights. Now, on the domestic civil rights side of the ledger, Vince began his career as a public defender with the Legal Aid Society in Brooklyn. And what Vince learned there as a young public defender surely must have informed his later work at the ACLU, litigating criminal justice and racial justice cases, and then later at CCR, during a decades-long campaign to transform the lives of communities of color who were experiencing discriminatory policing by the NYPD. And this led to the groundbreaking decision of Floyd versus City of New York, about which students in my current LPS class recently read. And that's just the tip of the iceberg for Vince's and CCR's civil rights work. On the human rights side of the ledger, Vince went to South Africa early in his career to monitor the historic Truth and Reconciliation Commission hearings there. And at CCR later, he has led efforts to defend the rule of law in wildly unpopular cases and contexts, such as defending detainees in Guantanamo Bay and Abu Ghraib, and more recently, to protecting migrants at the southern border. CCR has a long and storied history as well of holding multinational corporations to account for their involvement in civilian killings, environmental destruction, and more. So these are just a few of the many, many issues and cases and campaigns that Vince and the CCR have been involved in over the decades. The final note for me is that you've probably seen this in Vince's extensive bio in our program already, but Vince is also a storyteller who uses his position to speak out against injustice. Just last week, he was quoted in the New York Times in response to President Trump's order to start preparing Guantanamo Bay for criminal aliens. Vince condemned this order as a tactic to cast migrants and asylum seekers as the new terrorist threat. So in these turbulent times, we are particularly grateful to have a leader like Vince speak truth to power both inside and outside the courtroom. And we are thrilled to have him here today to share with us some of the lessons that he's learned from his long career as a public interest lawyer and leader. Please join me in welcoming Vince Warren.
So I'm Vince Warren. I'm the Executive Director of the Center for Constitutional Rights. I would like to thank Dean Kendrick and Professor Kim, and also Professor Chin Lei, who is a very good friend of mine, who I've known since he was a young boy, and for inviting me out here. This is my first time to Charlottesville, and it's really exciting. Okay, so there are 3 things you need to know about me before I get started. Thing number 1 is that I am a lawyer, but I really wish that I was a musician. Thing number 2, I am both a Mets and a Star Wars fan, so I think that anything is possible. And number 3, I actually am a bit of a call and response guy. So how you all doing? I was at another law school where there was a really robust response, and I'm wondering, hey, how you all doing? That's what I'm talking about. That's the kind of energy that I'm going to try to put out. That's the energy that you should feel free to shout back at me, whether you agree or disagree with what I am saying. So I'm the Executive Director of the Center for Constitutional Rights. As Professor Kim was telling you, I've also worked as a public defender. As I told Professor Lei's class yesterday, if you cut me, I still bleed public defender. So y'all are out there doing that work. It's extraordinary. I also am really excited about trying to tackle this intractable problem that is developing in our society right now. So I don't know if you've been following, but there was an election recently. And there's been a lot that's been going on. It's been 3 weeks, y'all. It's been 3 weeks. And over these last 3 weeks, the democratic principles which we hold dear are actually being stress tested before our eyes. There is great consternation about the balance of power, the dark, angry, violent worldview of this presidential administration, the role of corporations in our government, the impact on our government institutions, and the precarity of relying on the rule of law to fix it. And as overwhelming as these last 3 weeks have been, certainly for me and for many of us, we are actually wrestling with the same set of concerns that we were wrestling with 4 weeks ago, that we were wrestling with 4 years ago, that we were wrestling with 40 years ago. And the main difference between January of 2025 and December 2024, in my view, is that up until December 2024, we lawyers in the civil rights and human rights community have been relentless in our pursuit of curtailing the power of the state and corporations to deny the promise of justice for people. But as of 2025, we are now being called into curtailing the power of the president and corporations to deny the basic functioning of government itself. And these are two very different propositions. On the one hand, our historic mission is to defend people against the state, and on the other, we're now being drawn into the current tactic of defending the state against the state. And I would like to talk about this challenge from a perspective of a social movement lawyer, which can be considered a type of lawyering that exists as a subset of public interest lawyering or cause lawyering. But many of you know that CCR has really done some historic litigation. We've represented the men in Guantanamo. We did the stop and frisk cases. We ended long-term solitary confinement in Pelican Bay, California. We won a $41 million judgment in Virginia against corporations that were torturing people in Abu Ghraib. And you might be mistakenly in the view that what we do is we sit around and create our sort of some expertise and decide where do we want to point it. That we have an idea of what we want to do and we just need to find the plaintiff that's going to stand for it and where we're going to do that. That's not the kind of work that we do. What we are social movement lawyerings. So one way to think about social movement lawyering at a place like CCR is that our legal work centers around challenging and promoting respectively, kind of two things that the legal system itself doesn't explicitly recognize. The thing that we challenge is oppression, and the thing that we promote is liberation. These are probably my kids, yes, exactly. You don't have kids, many of you yet? Maybe you will. But one of the favorite things about me having kids is that whenever I'm speaking, somebody is calling me up to find out whether there's food in the fridge. And I'm like, bro, open the fridge. 3 boys, don't do it. So we view we promote oppression. I'm sorry, we promote, exactly. We promote liberation and we fight oppression. And these are not constructs that are really contemplated in our constitutional paradigm. What we do is we view legal possibilities, necessities, and interventions through the lens of critical legal theory, understanding that the law is not actually neutral. That there should be no neutrality in approach, there should be no neutrality in its creation, well, there is no neutrality in its creation, and there should be no neutrality in its expectation about how it's going to function. We know that when the law oppresses, it benefits those who are behind its enactment and its enforcement, and it disadvantages those who are its targets. And by focusing on representing the most marginalized people in our society, in this context, we very often are able to get outcomes that align more with what community needs are than what the law will allow them to get. Relatedly, though, our approaches also sees the possibility of liberation in the law, both in a practical sense of liberation, liberation of people, and abolition of the system they're liberated from. Two examples. One is the historic enslavement example, that the idea of liberation from that system needed to be fully realized and thought through as we were thinking about, as people were thinking about eliminating the system itself. I would argue that that is happening now also in the context of mass incarceration through the new abolition movement. And also we're thinking about liberation in a more metaphorical sense. We're doing work in Cancer Alley, Louisiana, the highest rates of cancer of any place in the country. It is a predominantly black region of Louisiana that's between New Orleans and Baton Rouge. Almost all of the black folks there are descendants of enslaved people, and they face the highest concentration of toxic industry on their land. So we can think about the work that we're doing in that, the legal work we're doing in that context also as liberation, the liberation of black communities from the toxic heavy industry that is permitted to operate in their communities. Why is this important? Well, I think the operating principles, the values, and the political frameworks that you go into looking at a legal problem will dictate, I think, what your solutions are likely going to be. And what I mean by that is that for people that assume that the law is neutral, it is very easy for people to make legal arguments that will may or may not advantage the person that's before them, but they're not thinking about the person that's coming next. My particular client has this problem. He doesn't meet the threshold and the criteria, so judge, you have to decide in his favor. All good, you get a win, it's great. The next person comes along, and the next one of you is going to do that. And that goes on and on and on. And when you think about it in terms of communities, if you think about it in terms of the public defender system, it is thousands of lawyers a day making the same arguments that will only have thousands more people a day coming into the system. That's why people call it the criminal legal system, and that's why many folks feel, particularly folks of your generation, feel that being a public defender feels more like working within the system than it is smashing it. I disagree with that, but it's an example of how when you look at the law as a neutral entity that you end up essentially with the status quo and no change. The Center for Constitutional Rights and the ACLU, I've worked in both places. I've been at CCR longer. Frankly, we're much better looking and more musically talented than the ACLU at the CCR, but be that as it may. The difference between the ACLU and CCR is that the ACLU's client, as you all know, is the Bill of Rights. It's the First Amendment. Thank God for the ACLU, because the First Amendment needs protecting. The difference, though, CCR, our client isn't the First Amendment, and it's not the Bill of Rights. Our client is social change. And that when you talk about social change and social transformation, you can't do that as lawyers alone. Lawyers can't access and lock in the idea of social change because we're just lawyers. We're really, really important litigators and technicians that can be used in service of social change, but we don't have those answers for ourselves. So in essence, for the ACLU, litigation is the means to the end of having vibrant rights. And for CCR, vibrant rights are the means to the end of social transformation. And so to give you a couple examples of this practically, I want to talk about a little bit about Floyd versus City of New York, Hassan versus City of New York, and the Guantanamo litigation. As Professor Kim was saying, that Floyd versus the City of New York was is a stop and frisk case. Some of you have read it in your books. By the way, BTW, when you work on a case or are responsible for a case and it ends up in somebody's law textbook, that's pretty doggone cool. And so the stop and frisk case, stands. Let me not say what it stands for because you can. I'm not going to give you the answer for Professor Klim's class, but I will say. Let me tell you the background and the context. So you might be mistaken in thinking that the stop and frisk case was the Center for Constitutional Rights saying, we need to find a 14th and 4th Amendment case against some police department somewhere because we think we can win. And it wasn't that at all. What actually happened was the opposite. 1999, social activists, people that had working in community on policing issues for decades, came to the Center for Constitutional Rights and they said, we have a problem. We said, what's the problem? They said, the problem is there is this group of police officers called the Street Crimes Unit. And the Street Crimes Unit, no badges, no marked cars. They would basically go around and throw black and brown people up against the wall and then basically put guns or drugs on them and arrest them. And we've worked with social movements long enough to know that the thing that you need to do is when people in the community come to you and say, this is happening, believe them. Because your job is now to go out into the world where nobody is going to believe them, and that the reputational risk that you're taking is that nobody is going to believe you. It's like there were certain, when I was at the public defender's office, my supervisor said, whatever you do, Vince, do not talk about race in your case. I'm like, but these were white police officers that called my client the N-word, and he's like, no, because it's going to turn juries off, it's going to make you less credible, and then people are not going to believe you. And they're certainly not going to believe your client. They don't believe your client anyway. But things have changed since then, but not a whole lot. But when your community clients come to you and say this is happening, almost no matter how outrageous it is, and it always sounds outrageous when they first come, you must believe them. You have to do a factual investigation to determine this. But then you have to be brave enough, and bravery isn't acting in the absence of fear, it's acting because there is some risk. You need to be brave enough to bring those cases and those facts to the court in ways that are compelling, hopefully in ways that are unassailable, and even then, there's a tremendous in you're losing. But the stop and frisk case started off as that situation. We issued a settlement. We got into a settlement discussion in the early 2000s, and the New York City Police Department was like, we're so sorry. We're never, ever going to stop and frisk anybody again. They put it in writing, and we started looking at the data, and all of a sudden, stop and frisk was on the rise. And why was it on the rise? It's a reason that will shock you. It's not because the police department got more racist, and it's not because the black people got more criminal. The reason why stop and frisk was on the rise, because when we looked at it in 2004, was because in 2001, after the horrible events of 9/11, federal money started flowing in to New York City to be able to stop terrorists from proliferating or meeting and that kind of stuff. And the New York City Police Department, which was also a recipient of these funds, applied a lot of that to their stop and frisk program. So they were more aggressively stopping everybody, but particularly black and brown people, which, at the time, I don't think fit the profile of Muslim terrorists, but it didn't really matter. So there was an influx of money that drove the investigatory stop and frisk practice that the New York City Police Department swore on a stack of Bibles they were no longer going to do. This is why the idea of thinking about critical law and thinking about law in the context of power makes sense. Because the issue isn't always what did the bad guy do to your client. The issue is who's the person that is driving, or what is the entity that is driving what the bad guy is doing to your client. In this context, it was actually the federal government. We didn't sue the federal government. But having that knowledge allowed us to really talk in complicated ways. This is early 2000s. Nobody was trying to hear back then that the federal government was rounding up black people in the context of stop and frisk because people felt afraid. They were driving the narrative of fear. But that was a discussion that needed to happen. Connecting to that, there's a case called Hassan versus City of New York. Different time frame, same police department, different ethnicity of people profiling. Hassan versus City of New York was a case in which, all right, this is it's a great jurisdictional question for you. The New York City Police Department in New York City, in the state of New York, was spying against Muslim people in mosques, in schools, in New Jersey, and in Connecticut. So that's how bold this program was. Literally, the New York City Police Department has no jurisdiction in any one of these places, but clearly had worked out something with the neighboring states to do essentially federal level FBI type spying operations on Muslim communities in 3 different states. And when we found out about that, not because the police told us, but because the Associated Press started doing these articles on this program of profile, it was called Mapping Muslims, essentially, is what we called it. And they were trying to map out in the mosques and the masjids and all of the places of Muslim community where the terrorists were kind of hanging out and where things were happening. They had confidential informants, they had financial incentives, they had all kinds of things. Of course, they didn't find anything. The thing, for those of you, well, many of you were not really around back then, but for those of us who were around back then, one of the things that we began to look at was the government was like, this is the most dangerous people in the world. Terrorism is the most horrible thing in the world, which it is. These communities, the terrorists come from these communities, so therefore these communities are going to be criminalized, and that should give us the ability to go in there and do stuff there that we don't do in other communities. That was basically the logic, in addition to yanking them up and throwing them in detention, which they also did. But when they went into these communities, you know what they would find? They would have confidential informants. The confidential informants would come back and say, I'm trying to get these guys to light a bomb or to do something. And what ended up happening is that people in the community, when they hear this guy, they would go to the FBI and the police and say, this guy's crazy. This is a guy you need to look at, right? So it never worked because when you criminalize a community, people in the community have all sorts of responses. And that's what was happening in this case. So we sued the New York City Police Department successfully, and we had a decision. We sued them in New Jersey, in federal court in New Jersey. Got a decision from the district judge in New Jersey on this is a massive spying case that the New York City Police Department was doing. The briefing was, many tens and tens of pages, and we got a 10-page opinion from the district court, which I still to this day think is like the functional equivalent of a fortune cookie, honestly. Like, you have a massive program and the judge basically says, well, it's not unreasonable given the events of 9/11, given the fact that the 9/11 hijackers were all Muslim, it is not unreasonable for the New York City the police department to have a program that seeks to investigate Muslim communities in New Jersey. I mean, it's that kind of logic which basically undergirded the entire 9/11 program. It goes from looking at the people that have committed horrible acts, extrapolating, and nobody wants those horrible acts to happen again, so it extrapolates and says that since they came from this particular community, we actually are in good legal standing to criminalize the entire community. And that's something we managed to defeat. We appealed the decision to the Third Circuit. We also got an amicus brief from the family of Fred Korematsu. Fred Korematsu was the lead plaintiff in the Korematsu cases that were challenging the Japanese concentration camps. And we were able to get different groups that historically had been part of this criminalization of communities to talk about it from their perspectives, and it actually worked. We had this extraordinary Third Circuit decision, and the Third Circuit decision said spying against Muslim Americans in New Jersey, we should have learned our lesson by now. We did it with the communists in the 1920s, and we did it with the Japanese in the 1940s, and we did it with the black folks in the 1960s. Then the court said, when are we going to learn and see with foresight what we already know in hindsight? was a very, very powerful moment where a court is actually moving away from the war on terror paradigm, the idea of fear, and then really centering the idea of rights, but not just building the power of rights. That court was really speaking to the power and preciousness of community. It's rare that you get those kind of decisions. I would say that it's because of the way that we frame the case. It could have just been the court was wrong. The plaintiffs have made in their complaint, have made a reasonable case for a Fourth and 14th Amendment and First Amendment violation. Case remanded. But they wanted to sing a little bit about what was at stake, which was quite extraordinary. Lastly, I want to talk about the Guantanamo cases. And very, very briefly, we filed the first Guantanamo case in February 2002. That was shortly after the first people were brought to Guantanamo in January of 2002. And back then, no civil rights, no human rights organization wanted to touch these cases. It was 6 months after 9/11, and it was horrible. 9/11 was horrible for everybody. And it also spoke to, I think, how nonprofits, legal nonprofits, all of whom really do see themselves as the bold lions of protecting our democracy. It also shows how vulnerable nonprofits can be in the space where there is great public concern and there's great public outrage. So no one but the Center for Constitutional Rights and a law firm and a death penalty lawyer wanted to file those cases. And so we started, I wasn't there at the time, I was at the ACLU at the time, which, by the way, was not filing those cases, that they started filing those cases. And it was met with, we got death threats at the Center for Constitutional Rights for doing that. People in Congress were outraged. The average citizen was outraged. The other nonprofits were like, that's just stupid. Like, why would you sink your organization by representing a bunch of terrorists? And for those of us who were pushing it forward, I was unsuccessfully trying to do so at the ACLU. This is why being a public defender and having public defender in your blood where it really, really counts is because regardless of what it looks like and what it feels like, if we're willing as a society to say, this group of people are so bad, they're so terrible, they don't get rights, not only do they not get them, because the government's not going to give them to them, but we're not even going to fight for them. Like, that's what was happening in the public interest community back then. And everybody thought CCR was crazy until the case went to the Supreme Court, and the Supreme Court recognized the right of the men in Guantanamo to habeas corpus. They got to file petitions in the courts to be able to determine whether they were being held illegally or not. Once that decision came down, guess what happened? Everybody's like, oh my God, we were with you from the beginning. This is great, rule of law, bad George Bush. That's another. Now, I know it sounds super shady with me, like throwing shade at all of the other organizations, but it's not, and I'll tell you why. Because one of the things that you will find in your work, I will promise you this, is that when you come up with the risky theory that you feel like justice demands and people are like, really? When you are successful, people will come and say, I was with you from the beginning. My advice to you is don't get too salty about it because you're going to need them. And it's okay for if you know that they know that you know that they know that you know that they weren't there in the beginning, that might be enough. But part of the leadership quality is actually taking that risk, and when that risk pays off, then you have to create an open door, particularly if it's a large, intractable problem. And that's what we did. CCR created the largest pro bono lawyer cadre in American history. 600 lawyers to represent 779 men. Most of the lawyers were from big law firms. I know a number of you may be thinking about big law, or maybe people outside of this room are thinking about big law. don't hate on them, because, when they come for whoever they're coming for, you're going to need all those big law people to work pro bono to do it. 600 lawyers for 779 men. There are only 15 left now. Which brings me to today. Part of the question that I'm sure that you're faced with is, well, thanks, Vince. This has been really interesting, but what the hell are we supposed to do? We're law students. I can tell you this. We've been waiting for you for a long time, because even though when I said that 4 weeks ago, 4 years ago, a number of years ago, we were still fighting the same battles. We were fighting the same battles. We were fighting them under different conditions, with different clients, under different presidents. But that is a battle that is at the core of the civil rights vision. And that's true whether you're fighting for trans rights. That is true whether you're fighting for immigrants' rights. It's true whether you're doing international law or whether you're doing domestic law. There is a fundamental fight. There's a problem in the United States that the United States has. It is by nature a punitive country. You know the stats. We incarcerate, we punish, we kill all sorts of people when we don't have to and when we shouldn't. And sometimes when the law says that that one shouldn't, but they do anyway, and then the law says, well, we can't really prevent. We don't want to second guess the state in their the way that they're thinking about things. But the thing that the journey that I'm hoping to enroll you in is the one that I've been on for a while, and I need you. I need people who bring these prestigious skills like you get here at this law school, but bring also the hearts of people that we are really thinking about outcomes for people. I need people with some grit also, the people that aren't necessarily afraid to go after the big boys and girls, people that aren't afraid of other entities disagreeing with them. At CCR, our clients have always been controversial, but if we don't lean in to the idea of building a better world for people, then we get caught up in the rhetoric of the state. So it is possible for the Center for Constitutional Rights to both be deeply against anti-Semitism and also try to hold the Biden administration accountable for its role in violating the Genocide Convention by supporting Israel. Both of those things are possible, but as you can imagine, it takes a certain amount of grit and rigor to make sure that you're not dragged into what ends up becoming government narratives. But we're in new water right now. We're in a place where we are looking at accelerating authoritarianism in this country. I won't go into all the details, but you can just sort of tick off the top 5 things. Number one, the executive claims the power to do pretty much whatever he wants, even like the wackiest stuff. I know you guys aren't watching because you're studying and stuff, but unfortunately I watch, and it's wacky. Number 2, that they're consolidating power in the executive, and they're consolidating power, at least democratically in this context, in the legislature and the executive. And now everybody is saying the president can do what it wants. Number 3, they have neutralized the independent press in so many ways by telling people they're just stupid, don't listen to them, and throw things at them and beat them up. And they also neutralize the press by just lying, and then when they're caught lying, they lie about the fact that they were lying, and then they say that the people that caught them lying are lying, and it seems to be working. And then finally, your Supreme Court is captured. It is captured. Why would I say a thing like that? It's that when you think about the U.S. versus Trump case, in which the Supreme Court wrapped itself in knots to try to talk about ways in which the president could or couldn't be held liable for his core duties, and I use his advisedly and on purpose because we persist in our inability to elect women as president, that he can't be held liable for his official acts. If he's got unofficial acts or a side hustle or something like that, we can talk about it. everybody was upset because it was Trump and felt like Trump should have been held accountable. But here's the legal thing that was unleashed with that report that I'm actually worried about. It's not so much whether Trump's going to go to jail. It's whether any president is going to be able to go to jail, because presidents are no longer, they're immune to criminal prosecution for core official acts. One of their core official acts could very well be, as Barack Obama did, unleashing a drone program to kill U.S. citizens in Yemen. It could very well be to send troops to, normally would think I was making this up, but in light of what happened this week, sending troops to Gaza to do forcible relocation of Gazans within his core duties, blanketly illegal. And what that means then is if you can't sue the president civilly for those types of violations, and we can't prosecute the president for those violations, and when I say we, I mean them, because I have no ability to prosecute no one. It is an entire political system that makes the determination as to whether sitting officials will be prosecuted or not. And in that sense, Donald Trump is right, because we wanted Barack Obama to prosecute George Bush and Donald Rumsfeld and all other sorts of folks for the demonstrable war crimes of torture, and he declined to do it. But the point is, the Supreme Court has now locked in the idea that the president pretty much can do whatever he wants. That should not cause you to crawl under your bed and go like this, la 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 la. What it should do is it should give you pause to consider the following question. Do you want a different world in 2050 than you have in 2025? I want it to be drastically different than what's happening right now. What's happening right now is we're seriously considering housing immigrants in the infamous concentration camp of Guantanamo for the purpose of stopping an invasion of migrants trying to come to the United States. That's what we're doing now, and I want it to be different in the future than it was 23 years ago, when we thought we could house and torture people in the offshore black hole known as Guantanamo based upon a global war on terror paradigm. And I want it to be different than it was 32 years ago, when we thought we could house Haitians in Guantanamo who were seeking asylum from a bloody coup in Haiti, and we put them in Guantanamo because under the on the fears of the spread of HIV and AIDS in the 1990s. 32 years of Guantanamo. It is a place that this country uses to dump the human manifestation of its political problems. And we need you. And even if you don't litigate those cases, I want you to understand the structure, the system that we're in. I want you to try your best to apply a power analysis to every legal case that you take on. I want you to be thinking not just about rights and not just about institutions. I want you to be thinking about people. Because if you use your legal brain to start with the premise of what is the best outcome for these people, and then you move accordingly, you will not get caught in the trap of saying the law doesn't allow you to do that. These systems will not allow you to do that. The balance of power doesn't allow you to do that. The deference has to be given to the decision makers, and you're not the decision maker. You will have to fight those battles, but you will not be implicated in them, because what you're trying to do is not make the system work better. You're trying to make outcomes for people and shape the system around those outcomes. So we need you. We need you quick. For those of you who are third years, thank you for your service at UVA Law School, but get out there, because shit's crazy. I had to say it. I managed not to curse almost the whole time. I want to thank you all for spending time with me. Thank you so much for inviting me to this wonderful, wonderful program. Thank you for thinking of CCR, and most of all, thank you for caring, for really coming out of this place with determination to make a difference. And in 2050, things actually could be a lot better. Thank you.